All right, welcome to Module 5. In this module, we explore civil liberties, which are essential protections afforded to individuals to ensure that they can lead an autonomous life. Autonomy is one of those things that we place a great deal of priority on. One of the first issues addressed in the text is how to tell the difference between civil liberties and civil rights. First, it's important to recognize that civil liberties reflect individual protections against arbitrary governmental interference. In contrast, civil rights claims emanate from allegations that an entire group of people, women, blacks, Hispanics, Native Americans, members of the LGBTQ community, etc., have been subjected to discrimination on the part of government, corporations, or some private person or entity. Civil liberties and civil rights protection also originate from different places in the Constitution. Civil liberties are generally related to the Bill of Rights, and they place constraints on the government's authority, but not on private individuals. The text notes examples of civil liberties that include the right to peaceful protest, the presumption of innocence for those accused of a crime, and the right to freedom of religious exercise. In contrast, civil rights claims emanate from the Fifth Amendment's guarantee of due process, but also, and perhaps more so, to the 14th Amendment's guarantee of equal protection and due process under the law. Examples of civil rights claims includes the right of citizens to live where they want, regardless of race, the right of naturalized citizens to vote, again, regardless of race or gender, and the right of same-sex couples to marry if they choose. So to summarize, civil liberties captures what the British philosopher Isaiah Berlin described as negative liberty, the freedom from arbitrary government interference, while civil rights reflects a positive duty on the part of government to correct past instances of discrimination. Another important insight to understanding civil liberties is their connection to specific amendments in the Bill of Rights. There is no substitute for brute memorization of the Bill of Rights. Just write the 10 amendments on a blank side of the 3x5 index card and then write out the specific liberties they guarantee. Then you're going to want to write out Supreme Court cases that, whose interpretations have kind of delineated the scope of those rights. Some amendments to secure, some amendments actually secure multiple liberties. When you talk about, for example, the First Amendment, it addresses freedom of religion, freedom of the press, freedom of speech, and freedom of assembly. Meanwhile, some amendments only focus on one issue. For example, the Seventh Amendment focuses exclusively on the right to a jury trial and the right that certain issues would be adjudicated by juries. The existence of the Bill of Rights is a reflection of the compromises that the Federalists, those people who supported ratification of the newly proposed Constitution, and the Anti-Federalists, with the Anti-Federalists who were opponents of ratification, and who were particularly upset at the absence of a federal Bill of Rights, given that most of the original states included such guarantees of personal liberty. The Constitution was originally ratified in the absence of a Bill of Rights, with the first 10 amendments ratified in 1791, 2 years after the Constitution went into effect. Electoral politics played a role in the creation of the Bill of Rights. James Madison was a staunch Federalist and ran for the House of Representatives in the first congressional elections under the Constitution in 1789. He drew an anti-Federalist opponent in James Monroe, which I believe was the first time that two future presidents would run for an inferior office against one another. Monroe campaigned on the promise that he would fight to include a Bill of Rights at the federal level. Madison had actually played a role in both the ratification debates in Virginia and later in New York, and he had helped the Federalists win the ratification debate in Virginia by personally promising to work to add a Bill of Rights. Despite running in a heavily anti-Federalist district, Madison narrowly won and persuaded his fellow Federalists in Congress, in the House of Representatives, that were now increasingly known as Democratic Republicans, that a Bill of Rights was essential to preventing powerful anti-federalist politicians from successfully calling a second constitutional convention and rewriting the Constitution to suit their ideological preferences. The politics surrounding passage and the ratification of the Bill of Rights was something that Madison actually characterized as nauseous. It was very high pressure stuff. So generally, when you're looking at these civil liberties, the protections guaranteed under the Bill of Rights fall into four kind of broad categories. The first, you have the protections of freedom of expression that are located in the First Amendment. Then you've got the right to bear arms, which is also located in the Second Amendment. Then you have kind of a throwaway, the right not to be forced to quarter soldiers in private homes. The Third Amendment, which is, again, not necessarily something that we think about a lot, but in fact, during the Civil War, both sides were pretty good about that. Then you have the fourth broad category, which, is important to recognize, and that is the rights of the accused. You have the Fourth and Fifth Amendments, which address pretrial rights of people who are accused, that is designed to preserve this notion that we are innocent until proven guilty. The trial rights of accused persons, the Sixth and Seventh Amendments, which ensure, again, due process over the course of a legal indictment. And then post-trial rights of convicted persons, the Eighth Amendment, which is one of my, it's an amendment that I'm particularly interested in, which prevents, punitive fines, but also the infliction of cruel and unusual punishment, whatever that might mean. The principal reason why James Madison was originally opposed to adding a Bill of Rights to the federal Constitution was his fear. Being a lawyer, he was fearful that listing rights might easily be construed as creating an environment where rights not listed would therefore not be protected. So with that in mind, Madison drafted the Ninth and Tenth Amendments. The Ninth Amendment, which basically states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Likewise, the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states respectively or to the people. So it's important to keep in mind when you're looking at this notion of civil liberties. Part of the genius of American jurisprudence is that there are no unlimited liberties. All liberties exist in balance with other liberties, and including those unlisted liberties like the right to privacy. In learning about constitutional law, you learn a lot about balancing tests. The fact that there are certain, your rights may conflict with my rights, and we have to figure out ways of synthesizing them. One of the classics is your right to swing your fist ends at my nose. In fact, you're simply doing that towards my face, whether you hit me or not. In many states actually constitutes or could be interpreted as constituting assault. So one of the more notable balancing tests is this notion between, again, personal liberty and national security. The chapter notes the Patriot Act, which was passed in the aftermath of the terrorist attacks of September 11, 2001, as an illustration of the need at times to sacrifice some liberties in the interests of defending against terrorism. The willingness of Americans to sacrifice due process rights when threatened by Islamic terrorists contrasts significantly with Americans' resistance to any limitation on firearms, particularly on high velocity rifles and things like that. The role of the courts in identifying the scope of civil liberties cannot be understated. Woodrow Wilson, ex-president, the first professional political scientist to be elected president of the United States, famously described the Supreme Court as a constitutional convention in continuous session. The reason why the state and federal judiciaries are so important has to do with the evolution of the American state over the course of the 19th and 20th centuries. And one of the most important reasons why the courts have such a substantial role in interpreting, the Constitution is the idea of judicial review, which carves out for the judiciary the power uh, of the federal courts to review and either affirm or strike down the legislative statutes, executive orders, administrative regulations, and the implementation of laws by the executive branch. Um, Whether judicial review is kind of viewed as an asserted power through the Marbury decision, the decision in Marbury versus Madison in 1803, or whether judicial review is a sort of reasonable interpretation of Article 3's vesting clause, which states that the judicial power, whatever we mean by that, shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. That's really going to be the question. My view is that the judicial power is a pretty vague notion, and that judicial review was actually an asserted power. Another important basis for judicial authority over state actions is Article 6's Supremacy Clause, which declares the Constitution, the laws passed by the Congress and passed and signed into law by the President, and all treaties negotiated by the President and approved by the Senate are the supreme law of the land. And therefore, in instances of conflict between state and federal law, the federal law prevails, and the courts are responsible for adjudicating those kinds of conflicts. The Supreme Court also has established what is known as the compelling interest criterion in determining whether specific limitations on personal liberties are constitutional. This is another example of sort of a balancing test where individual rights are weighed against a public interest. And the reading offers the illustration of the Supreme Court's 1972 decision in Wisconsin versus Yoder, where an Amish family in Wisconsin wanted to withdraw their children from public schools after completing the 8th grade because of their religious beliefs. The state of Wisconsin, though, required children to attend school until the age of 16. The court's decision was, at the time, that the state's requirement lacked a sufficient compelling interest to force those children to attend an additional 2 years of education. The question of whether the court would have struck down any sort of educational requirement, K through, 2nd grade, whether, that's a different matter. A lot of the homeschooling arguments kind of emanate out of this kind of situation. And again, in that instance, in that specific interest, it's a First Amendment belief, and the idea of religious convictions, and that's a very strong trump within within American constitutional jurisprudence. There have been instances where individuals' access to civil liberties have been severely curtailed. The assigned reading offers the example of the internment of Japanese Americans living in the states along the Pacific coasts in the aftermath of the Pearl Harbor attacks. The internment resulted in significant losses of property and businesses owned by Japanese Americans. A legal challenge to the internment, which was undertaken by Franklin Delano Roosevelt's executive order, was upheld in a case called Korematsu versus United States in 1944, basically on the grounds that the national security compelled such a dramatic curtailment of American civil liberties, the presumption being that the Japanese would fight on the side of Japan and seek to sabotage America's war effort. That view was proven by history to be not the case. Most Japanese Americans left Japan for a reason. They felt strong attachment to the United States, and there were virtually, as far as I know, zero instances of sabotage along the Pacific coast. Ultimately, the Supreme Court Chief Justice John Roberts overruled the Korematsu decision, writing, "The Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and has no place in law under the Constitution." So I previously mentioned the reaction to the terrorist attacks of 9/11 and Congress's rapid passage of the Patriot Act, which again, that significantly expanded the federal government's surveillance powers in order to protect national security. But some provisions of the Patriot Act were later struck down as violations of civil liberties. The example the reading offers is the Patriot Act's expansion of the use of national security letters, which allowed law enforcement to intercept communications without obtaining a warrant from a neutral magistrate. That provision of the Patriot Act was struck down in 2013. There are other areas in which civil liberties may be curtailed. For example, the right to freedom of expression is not unlimited. There is some speech that is not protected by the First Amendment. But the reading also goes on to note that even hate speech that is highly offensive is nevertheless protected by the First Amendment, unless that speech in question could reasonably be interpreted by law enforcement as advocating imminent lawlessness or violence. That's sort of the new test for what speech is protected versus what speech is not. Many critics of former President Donald Trump have argued that the speech he gave on the Ellipse on January 6, 2021 amounted to an incitement to riot. Despite calls from liberals to indict the former president, legal scholars have warned that the bar for proving incitement to riot or incitement to imminent lawlessness is very high. And carries with it the likelihood that the former president's supporters would accuse, the law enforcement people bringing the charges, of using the law as a political cudgel to cancel the former president. Time will tell whether any jurisdiction, particularly the District of Columbia, where the riot occurred, whether they'll decide to take that step. The assigned reading also notes the right to die as a controversial aspect of individuals' civil liberties. To date, 7 states plus the District of Columbia have assisted suicide laws that permit a person to end their life if a medical professional concludes a person is entering an end-of-life phase that is irremediable. The balancing test here is between those who believe that individuals have a right to die with dignity, and those who believe that all life is precious and should be preserved for as long as possible, regardless of quality of life. In the case Cruzon versus Director, Missouri Department of Health in 1990, the court held that Nancy Cruzon herself had the right to request that life-preserving treatments be stopped, but that her parents did not, in the absence of a clear indication of their daughter's preference. That led to a rapid, explosion of what we now describe as living wills and advanced directives that are clearly indicating a person doesn't want to be placed on life support in the event of a catastrophic accident or illness. The last thing from the reading that I want to discuss is the idea of incorporation. Initially, the Supreme Court had held in Barron versus Baltimore in 1833 that the Bill of Rights only applied to the federal government and not to state governments, many of whom had already had their own bills of rights. Ratification of the 14th Amendment fundamentally changed the nature of the relationship between the federal government and the states, as I mentioned in my presentation on federalism. And that gave rise to the notion of incorporation or the application of civil liberties protections to state governments. There's an important distinction between selective and total incorporation among legal scholars. Initially, the court took a selective approach, avoiding kind of blanket. They took it on a case-by-case basis. The first instance where the Supreme Court incorporated a freedom from the Bill of Rights was Gitlow v. the United States, which was handed down in 1925, where the court upheld Benjamin Gitlow's conviction under a New York sedition statute. He was a socialist who had opposed the U.S. entrance into World War I and called for the overthrow of the U.S. government. But the decision also warned that in non-war circumstances, that New York sedition law would violate the First Amendment. So hopefully this gives you, this presentation gives you a sufficient overview to get started. The remainder of the reading describes the linkages between specific civil liberties, constitutional amendments, and Supreme Court cases. If there's anything from this presentation or from the reading that you don't understand, please don't hesitate to contact me in the weekly discussion, ask a question, or contact me directly. All right, let's have a great week.